Welcome, everyone, to the panel Emerging Voices in Food Law and Policy, sponsored by the global full-service law firm Gowling WLG. This panel showcases exciting new research in food law and policy by current and recently graduated law students. I'm Stephen Wood, the director of the Center for Law and the Environment at the Allard School of Law at the University of British Columbia. If you've attended the other conference sessions, you'll already be tired of my voice, so I'll try and keep this short. UBC's Vancouver facilities are located on the traditional, ancestral, and unceded territory of the Musqueam Nation, as well as the Squamish and Tsleil-Waututh nations. And our participants today are joining from the territories of numerous other Indigenous nations. We acknowledge the Indigenous owners and caretakers of these territories. We're going to hear presentations by 4 students today. I'll now introduce each of them very briefly. If you'd like more detailed information, there are bio sketches on the conference website of each of the students. Undue Suffering has a JD degree from the University of Toronto and is currently completing a civil law degree at the University of Ottawa Faculty of Law. His paper is entitled Clearly a Subjective Determination, Interpretations of Undue Suffering at the Canada Agricultural Review Tribunal 2000 to 2019. Natasha Stansberry is an LLM candidate at the University of Ottawa Faculty of Law and will present a paper on A Roof Over Our Stomachs, the Right to Housing in Canada and its implication for food rights. Celia White is a JD candidate at the Osgoode Hall Law School of York University. Her paper is called Mexican Salsa and Mexican Farm Workers, How International Agricultural Development Marginalizes Farm Labor. And finally, Julia Whitmer is a JD candidate at the Schulich School of Law, Dalhousie University, and her paper is entitled How Law Shapes Food Sovereignty in Urban Canada. Each student will present for 15 minutes, and we'll need to stick closely to those time limits in order to finish on time. All of these students are exciting emerging voices in food law and policy worthy of recognition and encouragement, and one of them will be selected to receive the Gowling WLG Joel Taller Prize for Emerging Voices in Food Law. And I just want to give you a sense of who that is. The Joel Taller Prize for Emerging Voices in Food Law was established in memory of Joel Taller, who passed away on May 13th, 2017. Joel was a pioneer and well-known expert in food law in Canada. Joel practiced for 34 years in the Ottawa office of Gowling WLG, working with companies of all sizes. Joel was well respected by both industry and government for his legal expertise and sound judgment. He was instrumental in developing the food and beverage group at Gowling, a significant team of lawyers and scientists who support companies doing business in Canada, Europe, and other jurisdictions around the world. This year's Joel Taller Prize judges are Professor Bita Amani of Queen's University Faculty of Law, Professor Patricia Farnese of the University of Saskatchewan College of Law, and Professor Jacob Shelley of Western University Faculty of Law. Also, John Leckie and Mark Uden, a partner and associate respectively in the Vancouver office of Gowling WLG, and all of the judges are with us today. After the 4 presentations, the students will answer questions from the judges for around 20 minutes, and time permitting, but only if there's time permitting, we'll open to audience questions after the judges' questions are finished. The winner of the Joel Taller Prize will be announced at the conference closing session tomorrow at 1:15 p.m. Pacific time or 4:15 Eastern time. With those remarks, I would like to turn the podium over to our first presenter, Undue Suffering. So please go ahead, Andrew.
Hello, everyone. Bonjour à tous et à toutes. I'm very happy to be here. And I want to start with a thank you to the conference organizers, with a special thanks to Victoria Bayless and Professor Wood, and thank you for that introduction. And I also see that my professor, Sarah Berger Richardson, is in the audience, and I want to thank her for supporting this paper and for early feedback on a previous draft. And finally, a very warm hello to my fellow panelists. I wish I was next to you, Tasha, Celia, and Julia. I look forward to hearing from you. Okay, so now on to my paper, which is animated by a very basic question, which is, are our laws any good at reducing animal suffering? And at one level, of course, this question is absurd, because the most obvious way to reduce animal suffering would be to stop consuming animal products. But since vegetarians and vegans do not yet rule this earth, we have laws aimed at reducing suffering, even as we raise millions of these animals for slaughter. And my paper is about a very particular area of Canadian law, the Federal Health of Animals regulations, which purport to protect farm animals. And more specifically, my paper is looking at the concept of undue suffering, which is a concept that is interpreted and applied by the Canada Agricultural Review Tribunal and by the Federal Court of Appeal occasionally. And I'm looking at this over 20 years between 2000 and 2019. I don't have slides for you today because I don't trust my grasp of technology, but I just want to give you a brief roadmap of the 4 things I want to do today. First of all, I want to try to convince you that this research matters. Secondly, I just want to give an overview of my methodology broadly. Third, I want to look at the big picture of what I saw in the Federal Court of Appeal decisions and in the tribunal decisions and some major takeaways. And finally, I want to leave you with 3 main conclusions. So first, why was I interested in this question of undue suffering, and why do I think it matters? Well, first of all, in 2020, there were quite major changes to the regulations, and the word undue almost entirely disappears. And a document that accompanied these change in regulations issued by the government said, quote, said that transportation of farm animals should not, quote, lead to any degree of suffering. So I was thinking to myself, well, maybe if we look back at the last 20 years, we can assess the significance of this change and decide whether it's actually meaningful. Secondly, I think particularly these tribunal cases are worth looking at because they're one of the very few legal arenas where animal suffering is actually taken seriously, and where the contours of what is deemed permissible conduct towards farm animals is established one way or the other. And of course, the other notable places being in the criminal law and in the application of provincial regulations, which have been discussed elsewhere by Katie Stykes and Peter Sankoff, among others. But I don't think there's been much attention to these federal health of animal regulations as dealt with by the tribunal. And finally, I think these tribunal decisions are an incredibly rich factual record for us as usually the quite dark side of our meat supply chains. And these cases go into great detail about incidents where thousands of chickens die in crates en route to slaughter, where hogs are suffocating, sheep are freezing, and animals are being transported despite evident pain. And we learn things like, for example, that the Canadian Food Inspection Agency, which is enforcing these regulations, had a policy at a certain point, at least, where it automatically investigated a situation if 4% of chickens died on a given transportation. And the implication is that often when it was lower than that, it was not investigating. So very rich factual record for us to look back on. I was curious, and this is a question for the audience. I don't know if people can raise their hands virtually or actually. I'm curious how many of you have actually read a Canada Agricultural Review Tribunal decision. I know that at least one person has written many of them, but I'm curious how many people have actually read one before. I had not. I see Professor Farnese, Sarah Berger Richardson. So I've got 2 readers, it looks like, and one author. So that's not a lot. So I think it's worth our scrutiny, and very occasionally these are very well written documents, I would say. And I wanted to mention, I think Don, yes, I see Don Buckingham is out there, and I would like to recognize him as in my subjective view, the best author of these decisions. And for example, there was a decision that began, "This case," he wrote, "is about the life and death of spent hens on their way to a Canadian slaughterhouse." Great opening line. And there was my favorite, "This case is about a flying pig. It didn't really fly, but it did jump. And what caused it to jump is at the heart of this case." So I just wanted to whet your appetite for these great tribunal decisions. Now that I've got you excited about this great resource, I want to quickly describe my methodology. So as I said, I looked at the whole database of all these tribunal decisions for 20 years, between 2000 and 2019. And of these, I was looking very specifically at 157 decisions that interpret this concept of undue suffering. And we're talking about hogs and sheep and chickens and horses and cows. And the bigger context is that there's a monetary penalty system, which is enforced by the Canadian Food Inspection Agency, and they're levying multi-thousand-dollar fines if people violate these regulations. And I looked at 9 particular regulations, all of which invoke this idea of undue suffering, and they have to do with suffering during transport, during loading, during unloading, and caused by things like overcrowding, bad ventilation, exposure to weather. And just to give you one concrete example, I'm cutting out a lot of the legislative verbiage, but as one example, and this is at paragraph 138, 2A of these regulations, "No person shall load or transport an animal that cannot be transported without undue suffering during the expected journey." And it's up to the agency is giving these fines, and then it's up to the tribunal to decide, has undue suffering occurred? Indeed, if that's the issue that's being raised by the person contesting the fine. And I chose 2000 as a start date because that's actually the year that this administrative penalty system comes into force. Before, it was my understanding that it was largely in the arena of criminal law. And in 2000, there's this big change. So we have 20 years where the language and the regulations are quite constant. And so we can look at how the interpretations change over time. So how is undue suffering interpreted and applied? I'll just briefly mention 2 decisions by the Federal Court of Appeal that make a big impact. The first one happens in 2005, and it's written by Justice Nadon with the support of the court. And he says, well, undue in this phrase, undue suffering, means undeserved, unwarranted, unjustified, unmerited, unreasonable. And you may be asking yourself, well, these are a lot of vague words. I wonder how much work that does, which I think is a good question. But he reaches a very specific conclusion, which is that you shouldn't, there's a violation if you transport an animal that is already suffering or injured before transport. So that's quite clear guidance. But then 4 years later, in a case called Doyon or Doyon, Justice Letourneau says, well, actually, if there is suffering at loading, for example, it doesn't necessarily mean that transportation caused undue suffering. So really what this decision is doing is affirming this distinction between undue suffering on one hand and mere suffering on the other hand. And some suffering is okay, according to this interpretation, according to this reading of undue suffering, but undue suffering, not okay, there's a violation. And effectively, this 2009 decision breathes life into this word undue and gets it to do a lot more work. And if you're looking at it just from an animal welfare point of view, which is of course not what the regulations as a whole are trying to do, it looks like a step backwards from this 2005 decision, because it's saying some suffering is permissible. Now, when you look at these 157 CART, I sometimes say CART, that's an abbreviation for the tribunal, but I'll just say tribunal. You know, what do we learn? How do they identify undue suffering? And of course, we have Don Buckingham, who I hope has perhaps something to add at the end if there's time. But there were three main methods. The first one was look at guidelines, codes of conduct, which are not determinative, but they can be persuasive. And it's like tort law. The tribunal is looking for some objective way to judge reasonableness. The other main tool is look for external signs of pain, you know, where animals are communicating their pain. And there are things like labored breathing, wounds you can see. So that's obviously a big source for the tribunal. And finally, the tribunal looks to expert opinion, like notably veterinarians, and often the word of these experts prevails over often experienced farmers, though as time goes on, there's a lot of situation of dueling experts, as you might expect. And just to give a couple of concrete examples, the tribunal often finds that when there's very severe injuries, there's been undue suffering. And when there's death, notably, that's often associated with undue suffering. These are proxies for undue suffering. But for example, again, emaciation or really, you know, hernias or cows just bawling after a long transport, these were not seen to be sufficiently a sufficient amount of suffering to be considered undue. So without going further into the details of specific decisions, I want to leave you with three conclusions. First of all, the tribunal is clearly struggling with this distinction between suffering and undue suffering. And early on, the tribunal was saying, clearly this is subjective. And at first, when I initiated this study, I was looking for cases where the tribunal's recognizing suffering, but they're saying it's not quite enough to constitute undue suffering, which would, of course, would be the easiest way to distinguish between undue and mere. But that's not what you see. Rather, in no case did the tribunal actually explicitly recognize specific suffering, but then that it's saying, the tribunal says it's not sufficient. And I suspect that one of the reasons is that it's an uncomfortable thing for the tribunal to say. And indeed, in one case in 2016, the tribunal says, how an animal could ever deserve, warrant, or merit suffering is very difficult to envisage. And in other cases, the tribunal, in an almost pleading tone, asks for the Federal Court of Appeal for guidance. And they say, we welcome further judicial guidance in this area, ideally without any significant degree of judicial deference. A few quick more points. I think one of the big takeaways is that a vague standard like undue suffering is simply not an effective way to change behavior. The upside in general of a vague standard like reasonableness is that it can shift over time. In this context, as I mentioned earlier, there is a change over time if you look at the Federal Court of Appeal decisions, at least. From an animal welfare point of view, it looks like a bit of a regression. And generally speaking, again, the downside of vague standards is that enforcement tends to be limited to extreme transgressions, which are clearly unreasonable. And I would submit that a vague standard like undue suffering in this context is not in the interest of animals. And finally, I know I've just got a minute, but with respect to the 2020 changes, the word undue disappears, and the regulations become much more specific in saying whether an animal is fit or unfit. And indeed, this does seem like a very significant advance, and it does seem like a meaningful progress in terms of animal welfare, with two big caveats. One, a lot depends on how we define and interpret suffering, because we can see a scenario in which a lot of the work actually gets folded into suffering. And finally, the tribunal used to say that we make interpretations based on a balance between business realities and the well-being of animals. And that work happened in the word undue. And now it's unclear, how that balance is going to happen. Presumably it will continue to happen, and it'll be interesting to see how the tribunal tries to weigh those two big things. So I'll stop there. Thanks very much.
Thank you so much, Andrew. Perfect timing and a really fascinating presentation. I will move straight to our next presenter, Natasha Stansberry.
Sure. So I will just share my screen. Hang on. Okay. So, hi everyone. Thank you all for being here. And thank you, Andrew, for starting us off. That was awesome. I want to give a special thanks to Professor McLeod-Kilmurray, who's in the audience today, for connecting me with this project, and to Nadia Lombeck for earlier revisions of this paper. Thank you both so much. So before I start, just for some context, the initial draft of this paper was written as a community service learning project for Food Secure Canada. The ideas expressed in my paper have not formally been adopted by FSC, but I would like to thank them for the opportunity to have done this research. So my research explores the question of whether food rights advocates can look to the process of getting the right to housing legislated in Canada as a model in seeking to pursue the legislation of the right to food. There's already been extensive research and advocacy on shifting from a charity-based to a rights-based model to address food insecurity. So my research focuses on the how of the matter by looking at what happened with the right to housing. So the rights to food and housing are both embedded into several international human rights treaties. For example, both are recognized in the International Covenant on Economic, Social, and Cultural Rights and the Convention on the Rights of the Child. Until recently, Canada hadn't explicitly embedded these rights into its own legislation, despite being a signatory to both of these treaties, as well as a few others that include either one or the other. So in 2019, however, Canada passed the National Housing Strategy Act, legislating a right to housing in Canada. This was largely the result of pressure from housing advocates, including the UN Special Rapporteur on the right to adequate housing, to align Canada's legislation with the right to housing embedded in several international human rights instruments. The process for achieving the right to housing started long before the timeline covered in my paper. The Right to Housing campaign recognizes that the achievement of the right to housing in Canada was based on over 30 years of grassroots advocacy, engagement with UN human rights bodies, and court challenges. My paper deals mainly with the series of events from 2017 to 2019, directly surrounding and leading up to the enactment of the National Housing Strategy Act. So the legislation of the right to housing in Canada was really a case of the right people being in the right place at the right time. In May 2017, the UN Special Rapporteur on the Right to Housing, Leilani Farha, who's also a Canadian lawyer and housing rights activist, along with 3 other UN Special Rapporteurs, sent a formal communication to the Canadian government. The content of this communication was essentially an outline of Canada's obligations towards and failures to meet international human rights standards in the context of the right to housing. At this time, the Canadian government had already committed to implementing a national housing strategy. However, the UN Special Rapporteurs wanted the Canadian government to provide clarification on whether the right to housing would be the basis for the strategy and whether it would include effective methods of remediation and enforceability, as well as explicit reference to international legal obligations. The National Housing Strategy was unveiled in November 2017. The strategy makes several mentions of a human rights-based approach, but doesn't explicitly say that Canada would recognize and legislate the right to housing based on international human rights law. Shortly afterward, a group of key actors, including Leilani Farha and 4 other prominent scholars and activists in housing and human rights, wrote a draft National Housing Strategy Act. The draft legislation very explicitly recognized the right to housing and Canada's commitments to international human rights. In August of 2018, this draft legislation was released along with an open letter to Prime Minister Trudeau, signed by over 170 organizations and prominent Canadians, urging the Prime Minister to follow through on the commitment that he had made. Ms. Farha, in her capacity as UN Special Rapporteur, endorsed the draft legislation and was able to get it directly into the hands of the Minister of Families, Children and Social Development, who had been assigned responsibility for the National Housing Strategy. Although the exact draft was not adopted, the ultimate National Housing Strategy Act entered into force in July 2019 and included key elements of the draft, including the recognition of the right to adequate housing as a fundamental right, as well as explicit reference to international human rights mechanisms. This is an exceptional occurrence in Canadian legislation. It's actually super rare to see Canadian legislation that explicitly refers to international human rights treaties, even where it is relevant. But there are concerns that the NHSA doesn't sufficiently address the right to housing as it's outlined in the ICESDR specifically. So in all forms of international human rights law, there are 3 levels of obligations of state parties to an international human rights treaty: to respect, protect, and fulfill human rights. This includes an obligation to make available appropriate remedies to any aggrieved individual or group and appropriate means of ensuring governmental accountability. Although the NHSA includes the implementation of a review panel, this panel will not hear complaints from individuals about housing rights. Only selected systemic issues referred by the housing advocate will be considered for review. The system is designed to be efficient and targeted to the most important systemic issues, but it doesn't fulfill the obligation under international human rights law to make avenues of redress available to individuals claiming violations of their rights. So clearly, recognizing a human right doesn't inherently mean implementing the measures necessary to respect, protect, and fulfill that right. So that's something to keep in mind as we continue to work towards getting the Canadian government to recognize the right to food, or any other human right for that matter. So, as I said earlier, the process of legislating the right to housing had a lot to do with Ms. Farha being the right person in the right place at the right time. So Ms. Farha's being Canadian also may have been a key factor in this process. She was able to get involved with directly communicating with the Canadian government based on her involvement with Canadian organizations working on housing issues, as an extension of her work as a special rapporteur, but also outside of its particular parameters. She was also able to participate directly in putting together that draft legislation, and also in advocating for it to government representatives. So in this respect, it might actually be the perfect time to act on the legislation of the right to food in Canada. The UN Special Rapporteur on the right to food, Michael Fakhri, who I'm sure many of you recognize, is Lebanese Canadian and educated in Canada, although he's currently working in the US. If Ms. Farha's being Canadian and having connections in Canada was significant for her being able to push draft legislation forward during her term as a special rapporteur, it's possible that Mr. Fakhri could play a similar role. It is important to note that this wouldn't be the first time the UN has pushed for food rights in Canada, and other advocates have pushed for it as well. So as many of you know, Canada was visited by the former UN Special Rapporteur on the right to food, Olivier de Schutter, in 2012. In his subsequent report, he did recommend that Canada formulate a rights-based national food strategy and adopt a legal framework on the right to food. At the time, the recommendations were undiplomatically dismissed by the Canadian government. This visit was followed by other attempts to push for food rights policy, including a draft National Food Policy of Council of Canada Act in 2015, as well as an open letter sent to the Government of Canada in 2017 during consultations for the food policy by the ad hoc working group on the right to food, which I think several people here were involved in, recommending the recognition of a human right to food, a rights-based approach in all areas of implementation of the policy, benchmarks towards ensuring the realization of the right to food, monitoring and accountability measures, and clear steps to enshrine the right to food in law. A subsequent report by the Canadian government on the results of the consultation, recognized that participants wanted the recognition of a right to food as a human rights issue and the development of right to food legislation in Canada, but the subsequent policy is completely silent on the issue of the right to food. So yeah, the Trudeau government's interest in becoming more involved in international human rights was instrumental in achieving the right to housing, as mentioned previously. By contrast, the same government's apparent resistance to also implementing right to food legislation, despite multiple recommendations, is pretty discouraging. But well-timed international pressure in the form of a UN Special Rapporteur communication could be an important factor in future attempts to have the right to food legislated. And what do I mean by, well-timed? So it's all about the political climate, right? So COVID-19 has created a particular political climate around food justice that may make this a good time for that push towards food rights. There have been a lot of conversations surrounding public benefits about how the pandemic has revealed or unveiled vulnerabilities within the public benefit system, although people have been saying they've been visible for a long time, just purposefully ignored. Since the beginning of the pandemic, the Government of Canada has provided $200 million to the Emergency Food Security Fund to help food banks and food security organizations. Statistics Canada also released a health report on the impact of the COVID-19 pandemic on food security and mental health, which was actually one of the first studies to examine food security in the context of stressful events. The issue has also been discussed internationally by organizations like the International Labour Organization, and in September 2020, Michael Fakhri's first thematic report to the UN on the right to food highlighted how the pandemic has exacerbated conditions of food insecurity. At the same time, there also actually seems to be a growing trend towards recognizing human rights under international law in Canada. The Liberal government recently proposed legislation that would amend the Canadian Environmental Protection Act to formally recognize the human right to a healthy environment in the form of Bill C-28, which went through its first reading at the House of Commons on April 21st. The introduction of Bill C-28 is also the result of years of work of several actors and organizations pushing for change, as well as a comprehensive review of SEPA performed by the Standing Committee on Environmental and Sustainable Development. This review included extensive testimony by David Boyd, who is the current UN Special Rapporteur on Human Rights and the Environment. This could be another good sign for the significance of Canadian UN Special Rapporteur involvement in the advancement of rights in Canada. So now we come to potential barriers, because of course there are many. So barring rights under the Canadian Charter of Rights and Freedoms, rights legislated at the federal level do not automatically apply to matters falling under provincial jurisdiction. Legislation passed by the federal government is only independently applicable to areas of federal jurisdiction. A federal act can introduce or be attached to a national strategy, which can include opportunities for provinces and territories to make agreements with the federal government regarding the rights at issue. Signing an agreement with the federal government does not mean that provinces become bound by the relevant federal act or bound to guarantee the rights written into that act. However, agreements between provincial and federal governments can include clauses which, on a practical basis, will embody the delivery of those rights, sort of, through the delivery of particular services or programs. So for example, the National Housing Strategy contains several elements of partnerships between the federal government and provinces, territories, and by extension, their municipalities. One of these are bilateral agreements, which are made between the Canada Mortgage and Housing Corporation, or CMHC, and each of the provinces and territories individually. These agreements are not mandatory, but elements are incorporated into the strategy to incentivize provinces to participate. Each province and territory in Canada has signed a bilateral agreement with the CMHC. Each of these agreements, except the one with Quebec, includes a clause saying that the action plan will complement the National Housing Strategy goal of helping advance the progressive realization of Canada's obligation in relation to housing under the ICESDR. Whether this amounts to an actual guarantee of that right under provincial legislation is, I would say, unclear at best. The clause addresses specifically the content of the action plan, but not necessarily its delivery. Therefore, although programs and services under the action plan must be designed in a way that forwards Canada's commitment to the right to housing, a failure to deliver those design programs and services correctly may not be challengeable based specifically on a claimed violation of the right to housing. Another concern is that there are housing rights under the ICESDR that are not covered by the NHSA due to jurisdiction issues. Housing rights issues like protection from eviction, rent increases, and development-based displacement or rent evictions fall under other laws, many of them provincial or municipal. This means that the NHSA alone is not sufficient to guarantee all of the rights associated with housing, as each province would have to independently amend each of their respective relevant laws to recognize and protect the right to adequate housing. So similarly, jurisdiction has long been an issue in food rights advocacy and might be part of the reason that the right to housing has been recognized while the right to food hasn't, despite similar and multiple attempts. Arguments for the legal recognition of the right to food have been countered by those supporting the expansion of markets and improvement of economic outcomes. These market-based principles largely form the basis of the current food system in Canada. Unlike the National Housing Strategy, the food policy for Canada doesn't engage at all with partnerships with provinces, except in the creation of a national school food program. Instead, it aims to strengthen existing community-based projects that increase access to food through investment. This is reflective of the market-based system. It may be difficult to convince provincial governments to reduce their interest in agricultural market expansion and exports for the sake of realizing a right to food. This is not a particular challenge in the context of housing. The 2012 report of the Special Rapporteur on the Right to Food clearly acknowledges the vital role of national strategies in carrying out a federally recognized right to food. So it is possible to do it under a national strategy. Mr. DeShooter's first recommendation that the Canadian government formulate a comprehensive rights-based strategy that clearly outlines the responsibilities of public officials at all levels of government is imperative to make sure that the rights obligations are actually carried out. This includes ensuring that all initiatives adopted at municipal and provincial levels are adequately supported. Another important differential factor that may be a significant hurdle is the fact that the food policy for Canada has already been fully formed and enacted, whereas the National Housing Strategy Act had not even been written at the time of the advocacy that I've been discussing. this may present significant challenges in terms of being able to apply a similar model in regards to the right to food. However, the ongoing implementation and potential amendment of the food policy for Canada could be hugely influenced by a legislated right to food in Canada. Additionally, the food policy for Canada does create opportunities for the exploration of further sub-targets by the Canadian Food Policy Advisory Council, suggesting that there is room for the introduction of other commitments within the scope of the food policy for Canada. So in summary, there are many potential barriers to the success of another attempt to legislate the right to food in Canada, such as complications of jurisdiction and previous resistance to the right to food due to the prioritization of market expansion. However, there are several other factors that point to future possibilities for the legislation of the right to food in Canada. The process for legislating the right to housing could be looked to as a starting point, but factors differentiating the history of the push for the right to food and the nature of the current legislation that exists adjacent to it must be taken into consideration in future advocacy for the recognition of the human right to food in Canada. And I think that's my time, and I'll end there.
Perfect. You're actually around 20 seconds ahead. So thank you so much for that fascinating presentation as well. And without any further ado, I'm going to hand over to Celia.
Thank you, Stefan. I'll share my screen. Okay, so hi everybody, my name is Celia White and I'm presenting to you today from Nanaimo Territory on Vancouver Island. For the next 15 minutes, I'll be talking about how the ethos of international development, so this idea that people or places ought to be developed as a form of progress, as a way to make the world a better place, has shaped global agricultural systems today and has configured farm labor. I'm going to argue that the ethos of international development has actually worked to marginalize the people and communities who grow our food, despite narratives of increased food security and progress. And as embarrassing as it is to admit, I want to contextualize my presentation with a personal story from my youth, when I was involved in an international development initiative. I was in 10th grade. I imagine, like some of us here today, I was eagerly involved in volunteerism, and I hosted a huge fundraiser dinner to benefit healthcare projects in rural Mexico. The fundraiser was an example of promoting international development. So the idea that underdeveloped communities could benefit from intervention for things like improved healthcare, food security, and education. My group hosted this elaborate Mexican dinner where we made all the fresh dishes, and the most popular dish was probably the homemade Mexican salsa, which was made with fresh limes, tomatoes, garlic, onion, cilantro. It was really good. But as I was cooking, these questions started to go through my mind that probably many young volunteers face at some point in their careers. I started to wonder where these ingredients came from, who grew them, where were these people from, what conditions did they work under? And when I went home that night and did my own research, I found that the Mexican salsa ingredients were most likely farmed by Mexican farm workers. And it kind of hit me that these Mexican communities that we were raising money for were possibly the same communities who grew this very food. And I wondered if, despite raising money for rural healthcare, was this meal actually contributing to poor health and entrenched poverty in those communities because of the cheap food that we were importing? And it's those questions that I want to focus on today. I want to analyze how capitalist agricultural systems, as prescribed and controlled by the paradigm of international development, have impacted the laborers who grow our food. And I will argue that despite the narrative of international agricultural development claiming to benefit rural communities, the farm workers' labor is effectively devalued through neoliberal policies, resulting in the marginalization of their health and livelihoods. And to do this, I will be using the case study of the salsa dish and the ingredients of limes, tomatoes, onions, garlic, and cilantro to walk through the impact of international development on farm labor. But to begin, I want to talk about this concept of international development. Today, we probably know it as something along the lines of the United Nations Sustainable Development Goals. So projects that offer interventions for the betterment, whether that be for the health, the environmental sustainability, the economic security of communities around the world that are conceptualized in some way as impoverished. Communities often referred to as the third world or the global south. But international development has not always been conceptualized as progress for the global south. its history is actually rooted in colonization, where imperial powers sought to develop their colonies with things like roads, intensive agriculture, and capitalism in order to transfer resource wealth back to the motherland. So international development was not originally aimed at benefiting the colonies, but rather was intended to consolidate wealth for the imperial powers. The concept of international development became kind of twisted and conflated with ideas of benefiting the global south in 1949, when President Truman popularized the term underdevelopment in his inaugural address. This word introduced the new idea that people or places could be underdeveloped. And in this way, the word also introduced the idea that development was a necessary and a good thing. Whereas international development projects like roads and intensive agriculture and capitalism were previously formulated as simply a means to an end of wealth accumulation, now these projects were repackaged as interventions that would help the poor, underdeveloped global south. To be clear, they were pretty much the same projects, just with different packaging. The old packaging conceptualized the global south as merely resources for wealth accumulation. The new packaging conceptualized the global south as an underdevelopment problem that required top-down development to save. And intensive agriculture was one such project. Rather than seeing peasants as merely a source of labor for colonizers, the lens of underdevelopment reintroduced rural peasants. Sorry, I'm having trouble with my slides here. Reintroduced rural peasants as, and I quote, diseased, underfed, uneducated, and physiologically weak. Thus a problem requiring development for their own sake. At the same time that the small-scale farmers and rural peasants were being reconceived as a problem, the global food crises of the 1970s and early 2000s also highlighted hunger as another global problem that the international development paradigm ought to fix. After each global food crisis in the 70s and 2000s, the World Bank released a report introducing the concept of food security as equally important to other common international development projects, such as education or sanitation. However, the World Bank conceptualized food security as the ability to purchase food, rather than the ability to access food more generally, such as the ability to grow food, for example, and shifted the conversation about hunger toward narratives of price stabilization, trade liberalization, and participation in global capitalism. So we have these two ideas sort of running parallel. One is that small-scale farmers and rural peasants are backwards, underdeveloped communities who need to be developed. And the other idea that price stabilization, trade liberalization, and global capitalism are necessary to feed the world. And taken together, we get this silver bullet solution for international agricultural development. This idea that promotes intensive, highly technologized, monoculture, cash crop food production in global capitalist systems as both a means of progress and a solution to end hunger. And as we can see, evidence of these two ideas running in tandem through global legal systems. In 1947, the General Agreement on Tariffs and Trade promotes widespread market liberalization. Immediately after, in 1949, Truman coins the term underdevelopment, conflating market liberalization and social progress. After that, in 1986, the World Bank first introduces the concept of food security as an ideal standard for which international development should aim. And then in 1995, the World Trade Organization and NAFTA deepens and widens the impact of GATT, including the liberalization of agricultural markets. And it is these historical concepts of international development and recent history's legal systems of free trade that set in motion a hegemonic paradigm that prioritized market liberalization and mass food production over a fair and just valuation of farm labor. Because even with the shiny repackaging of underdevelopment, even with the objective of feeding the world, farm labor was still just a means to an end of agricultural development and mass food production. There was still an entrenched dynamic of coloniality and a hierarchy between the backward and inferior producers and the properly developed consumers, or between the underdeveloped rural Mexican peasants and the developed Canadian youth hosting fundraisers for their benefit. So now we're going to switch gears a little bit. I wanted to give you a background about how the international development paradigm has shaped agriculture, but now I want to get back to my argument that international agricultural development has effectively devalued labor at the expense of the farm workers' health, well-being, and livelihoods. And I want to look at the case studies of the salsa ingredients to showcase how international agricultural development affects farm labor in real-life examples. So to begin, I'll look at limes, the fresh limes probably Persian limes, most likely coming from Veracruz, Mexico. And to give a bit of background, between 1980 and 2014, so around the same time the World Bank introduced the idea of food security and market liberalization as necessary to feed the world, fruit production in Mexico shot up 131%, and Veracruz suddenly became known as the citrus capital of the world. And as we know, the model of intensive agriculture propelled by the international development paradigm promotes large agribusiness as progress for underdeveloped small-scale farmers. And when large agribusiness enters a community, smallholder farmers are displaced and dispossessed from their ancestral lands, a process known as depeasantization. And with depeasantization comes mass migration. With few other options available to them, peasants and small-scale farmers often choose between relocating as farm laborers elsewhere in their country or signing on as migrant agricultural workers abroad, which leads many small-scale farmers to Veracruz to work in lime plantations. The international development paradigm suggests that when small-scale farmers enter the global economy, they benefit from higher incomes. But the reality is that even though farm workers are included in the economy, they're not included on advantageous terms. You can see evidence of their marginalization by the rates of malnutrition in their communities, despite growing large quantities of food. Veracruz farm workers have some of the highest rates of malnutrition in the world because they do not control their food sources, they cannot afford to purchase the food they grow, and they do not have access to land. And they also face ongoing structural violence, such as exposure to synthetic fertilizers and pesticides. On Veracruz lime farms specifically, residents and workers suffer from acute intoxication, irritation of the respiratory tract, eyes, and skin, diseases that lead to premature death, genetic damage causing chronic degenerative diseases, and neurological and endocrinal damage in children under 12. The next ingredient I want to look at is onions, garlic, and cilantro, which were most likely grown in Ontario and BC in Canada. And many of the folks who work on these farms in Ontario and BC are migrant agricultural workers who possibly were the same workers who were displaced by the large agribusinesses in Mexico. So I want you to think back to the processes of depeasantization, migration, and marginalization that led them to these agricultural systems in the first place. The migrant workers here are governed by SOP, the Seasonal Agricultural Worker Program. They're mostly non-unionized, and although their workplace protections are upheld by laws in Canada, including the Employment Standards Act, the Human Rights Code, the Occupational Health and Safety Act, the Workplace Safety Insurance Act, the precarity of their situation actually makes them really vulnerable to human rights and health violations. As Annalise Wheeler said in her presentation yesterday, in some cases, putting profits over people has cost workers their lives. And a lot of this vulnerability comes from the closed work permit system in Canada, where their labor is tied specifically to one employer. So if their employer decides to let them go, they're simply sent home. So standing out by seeking legal reparations for violations of the laws in Canada would be far too risky for anyone who wanted to remain working in Canada. And the violations are vastly documented. For example, farm workers in both the United States and Canada suffer from more chemical-related injuries and illnesses than any other workforce in their respective countries. Which brings us to the United States. The last ingredient in the salsa dish, which is tomatoes, most likely grown in California. Due to the proximity of California to the Mexican border, many of these workers are undocumented. So they often live in squatter settlements around the farms where residences are reported to lack basic infrastructure such as running water, sewage, and paved roads. When the laborers arrive, they already owe their employers money for transportation, and this debt builds up as they're lent clothes and food on the farm until eventually it creates a dynamic of indentured labor. And unless they are fired, security guards actually prevent these workers from leaving the squatter camps. And although the United States has legal protections similar to Canada, the National Labor Relations Act actually excludes farm laborers from most of these laws. So for example, they are not guaranteed a minimum wage. They're not allowed to organize unions or protests. So we've come full circle now with an understanding of how international development shapes agriculture and how the shape of that agriculture marginalizes farm labor. But before I end my presentation, I want to just briefly talk about possibilities for the future. It's a bit too soon to say exactly the kind of impact the new USMCA is going to have on labor standards, but I can say that it uses much stronger language than NAFTA. Chapter 23 of the USMCA, for example, says that countries must adopt and maintain the International Labour Organization's core labor standards, which is unprecedented. But as we saw in Canada and the United States, the existence of labor laws does not necessarily mean that people on the ground will have access to those laws. In the very first part of the conference, Al and Hannah asked, how can Indigenous communities access their rights without sovereignty? And I think the same question can be applied today to the workers who farm these salsa ingredients. If they do not have control over their land, their labor, and their livelihoods, how will they stand up to the oppressive system of international agricultural development? I still often think back to that Mexican dinner fundraiser, and I wonder whether it was more helpful or harmful to the rural communities we were raising money for. And although I can't trace each ingredient back to the individual stories of each person impacted, my research did show that overall, the ethos of international development has led to depeasantization, migration, marginalization, and structural violence. And I know overall, because of that, I will be thinking twice about any fundraiser I do again in the future. Thanks, everybody.
Thank you very much, Celia. That was really great and even farther ahead of time than Tasha. So I will not waste any more of our time, and I'll go straight over to our final presenter, which is Julia Whitmer.
Hello, everyone. My name is Julia Whitmer, and I'm a JD candidate at the Allard School of Law at Dalhousie University. Today, I will be presenting on my paper, How Law Shapes Food Sovereignty in Urban Canada. And before I dive into the actual content, I do want to recognize that I am currently in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people, where I currently live, play, and study. And I want to thank the CAFLP for selecting my paper. I feel very honored to be here sharing my work. And it's also a real honor to listen to the other three presenters. So we'll dive in. So, sorry, a bit of a roadmap. I'm going to start with a brief introduction on why I wrote this paper, look a bit at the methods and data collection, a bit of background definitions, and then dive into my legal analysis, which was split up by constitutional law, municipal and planning law, and finally health law. I will touch a bit on research limitations and finally a conclusion and next steps. And this is a pretty high level overview of my paper, so I'd be happy to share, if anyone's interested, a bit more in detail after the conference. So a bit of background. In 2017-2018, 1 in 8 households in Canada were living food insecure, with the highest rate among Black and Indigenous households. And as you can see from this slide, these headings are all from the past year. The pandemic has shone light on the insecurities in our food system as a whole, but also put those who are most vulnerable in even more vulnerable situations. You can see here in the first heading that it is looking more like 1 in 7 Canadians experiencing food insecurity rather than 1 in 8. But throughout the pandemic, there was also a lot of positive headlines, as you can see on this slide, where community come together to improve access to food and food security. And these are just a few examples within the last couple months. So culturally sensitive food boxes, community fridges, seed keeping. And I was really interested in community work, but I wondered, where's the law in it? So my research question for this paper is, what legal instruments are employed to restrict or support food sovereignty in urban Canada? I wanted to look at the activities that often you might not think there's law behind, but law is always there. Before I dive into the specifics, I think it's helpful to tell you the research contributions I believe the paper has first. Firstly, I believe it provides one perspective on how the law shapes food sovereignty in urban Canada under the specific theory of the right to the city. And I'll expand a bit on those terms in the next few slides. Secondly, I believe it contributes to the broader study of how law plays in all food realms, whether that's food advocacy, food sovereignty, food access, food justice. And thirdly, I do hope that it offers a bit of a practical analysis for folks who are involved in food sovereign activities. The law will always be at the back of what everyone's doing. So if you can know the legal architecture, that can be harnessed when making activities. So what was my method and data collection? There's three key steps for my research portion of the paper. It started by gathering a data set, which was entirely academic literature, which I identified food sovereign activities within. Once the food sovereign activity was identified, I located the specific legal instrument that was behind it. And then I characterized this legal instrument as either supportive or restrictive of food sovereignty based on the 7 pillars of food sovereignty. So I feel like I've already used quite a few terms that everyone might not be familiar with. So I'll start by a bit of a background. As I mentioned, I was really interested in just figuring out where the law was located in these on the ground community initiatives. And so I came across the theory of the right to the city, and I felt it fit really well with the type of work I was looking at. The right to the city is a collective right to claim a shaping power over the process of urbanization and the way in which cities are made and remade. So rather than claiming an individual right to food or something like that, it's a right to reimagine how we live. And it can be a bit utopian, but I think it offers us the ability to get out of our current systems and push on change. I was interested then to see where food advocacy could fit into the definition of the right to the city. And I found food sovereignty made the most sense. It's important to note that in my paper, food sovereignty was separate from Indigenous food sovereignty, as there was no ties to indigeneity. But I followed the definition of the right of communities, peoples, and states to independently determine their own food and agricultural policies. Food sovereignty was developed through the agricultural peasant movement, La Via Campesina, where 6 key pillars were created and a 7th added after. And the 7 are on this slide. They're really important because these were what I used to analyze if a legal instrument or law was acting in support or restriction of food sovereignty. So they're focusing on food for people where all have access to healthy and culturally appropriate food and where people are at the center of the policies. It involves building knowledge and skills, working directly with nature, the food system, valuing food providers, localizing food systems, similarly putting control of food systems locally, and recognizing that food is sacred. Sorry. So a few examples of food sovereignty activities, just so you can have an idea of what I was looking for in the literature, I believe can be divided into 3 main categories. 1, anything that is striving to reclaim a public voice in the shaping of food systems. So this could be involvement in municipal food policy councils, co-governance, etc. 2nd is just straight policy or institutional change. This can be at a municipal level, say bylaws, ordinances, for example, declaring individual towns food sovereign, but also it can be rejecting corporate food within the institution. 3rd category, which I believe I was thinking the most of, if you think back to those headings, is independent citizen work. And this can look like really anything, but shared urban fridges, urban agriculture, even growing a fruit tree in your front yard and sharing with a neighbor, community shared agriculture. So diving into the actual legal architecture, I'll start with my first section of the paper, which focused on the constitutional law of food sovereignty. Overall, I found that the Constitution acts to be more restrictive on food sovereignty than supportive. And there's 3 key ways in which it restricts food sovereignty. Firstly, it restricts food sovereignty by not recognizing local governments as true governments. They are only seen as creatures of the province, and by this failure to recognize and constitutionally protect them, it restricts food sovereignty because it puts the power farthest from the people. Local governments are situated closest to the average person, allowing for a key area to fulfill the pillars of food sovereignty. 2nd, it limits the role of provincial government on agriculture. So although provinces do have a lot of control over agriculture, under Section 91 and 95 of the Constitution, as well as the doctrine of federal paramountcy, the feds do still have ultimate legislative power. And this matters because they can still have the end say, putting the power again farther from the regular person and community. The third way it restricts food sovereignty is by treating food as a commodity. If you look at any of the legislation or policy documents produced by Agriculture and Agri-Food, or looking at trade laws, it's viewing food as a commodity rather than a sacred aspect and something everyone requires. And that in and of itself is restricting food sovereignty. That being said, which my supporting kind of counters all of these things, by assigning jurisdiction to the federal government, it is in fact supportive of food sovereignty, or can be. So although providing all this power to a federal entity is against a lot of the pillars of food sovereignty, if it is harnessed correctly, it can be supportive. So for example, the federal food policy Everyone at the Table would not have been possible if the federal government did not have jurisdiction. So that can be viewed as supportive. My second category was the planning law of food sovereignty. I found overall municipal and planning law to be supportive of food sovereignty more than restrictive. And I would note that this section of my paper is quite heavy and there's a lot of legislation throughout, so I won't be referencing them specifically in this presentation. But I found it was supportive for three key reasons. Firstly, it enables local governments to plan and regulate. This allows local governments to make context-specific decisions. It allows them to work with the people and find what they need and support community initiatives. Secondly, it supports food sovereignty by enabling local governments to act creatively. Creative responses may include community initiatives, grants and funding, or for example, donating space and human resources for community gardens. Thirdly, it supports food sovereignty by allowing local governments to use alternative governance structures. For example, a local food policy council would exist under a municipality, which gains its power from the provincial statute. Now, this all being said, municipal and planning law can be found to be restrictive of food sovereignty because they get their powers from the provincial statutes, which are often broad in scope, which is great because it leads to all the supportive aspects, but there's no hierarchy of purposes provided. And this means that, for example, the city of Kitchener was able to prioritize business development and growth over access to food. And finally, the third area of law I analyzed was the health law of food sovereignty. Now, this part of my paper was a bit smaller, but I found it could really depend on the context, whether it was restricting or supporting food sovereignty. I did find that it restricted food sovereignty when it prioritized health safety over the other pillars of food sovereignty entirely. Health is a part of food sovereignty, receiving healthy food. So this isn't always going to be restrictive, but for example, there was a meat inspection law in BC, and they changed the regulation for health safety purposes, but the regulations actually ended up only allowing large corporations to be able to meet them successfully, and it really moved away from local food. Secondly, it can be supportive of food sovereignty because it offers another avenue to create the right to the city and food sovereignty. For example, the Toronto Food Policy Council was created under a health legislation, namely the Health Protection and Promotion Act, rather than a municipal one. So that was a very quick overview of my work, but I want to speak a bit to some of the research limitations. Firstly, my search strategy, I started by finding the activity first and then the law. I think there's probably a lot of legislation that restricts food sovereignty, but might not even mention food. Second, there was possibly a few missing considerations. For example, I didn't really consider the role of corporate and agri-food, especially on municipal governance, and how that may influence how they work for the people. And third, there was some subjectivity in my decision of whether or not the legislation or law was restrictive or supportive based on the pillars of food sovereignty. So, ideas to cultivate next. I think there's a lot we can take possibly from my paper for future research, but firstly, I think the idea of the right to the city or utopian ideals of pushing on systems is interesting way to start papers and a bit more theoretical. Secondly, there's an option to maybe try to locate those more neutral laws and how they affect food sovereignty. Third, I think there's a practical option here, and possibly even working with food sovereign groups on the ground to see what legal architecture is behind everything they're doing. And is there a way that we can work within it better, or are there systems that maybe could be changed? Yeah, and fourth, I would be really interested in looking more at health law, specifically food safety, to see how that is supportive or restrictive of food sovereignty and how those two can work in tandem moving forward. So that is my entire presentation. I did go through the law quite quickly, so I'd be happy to expand on it with anyone after the fact. My email is listed here. And again, I really appreciate the opportunity to present this work. Thank you so much.
And thank you, Julia. You've also come in under time. So if the efficiency of these 4 presentations are any indication of future, I think that academic conference goers will be very grateful because I've never seen an academic conference panel that is so efficient with time. Congratulations on that. It is now time to hear questions from the judges. And unless you've agreed a different order, I would propose to go in alphabetical order, starting with Professor Amani. Let me know if you have a different idea. And given the very limited time we have, it might make sense for us to plead with the judges to start out at least by just asking 1 question each. And if we have time for a second round, we can continue. So is that okay, Professor Amani?
That's great, thank you. So I just want to start off by thanking the presenters for excellent presentations and papers, and to thank the conference organizers for yet another year's fantastic program, but also for inviting me to be a judge and to ask some questions and to participate in the events in this way. I join you from Toronto, the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Haudenosaunee, the Chippewa, and the Wendat peoples, as well as now home to many different First Nations, Inuit and Métis people. I'm grateful to live, play, and work here as an immigrant settler. Noting from Iran, actually, with a Persian line. So that was an interesting bit of information I learned today. So I want to start off by, again, acknowledging the fantastic work that was done by all the presenters here. All 4 papers provided really thoughtful and timely conversations that address the dynamics of food law and governance systems in a way that seeks to either reduce harm or maximize benefits, or the distribution of benefits, references rights, through looking at the various aspects of these as reflected, however, between the intersections of individual choices in some regards, but also broader embeddedness within existing governance structures, individual, and I also mean institutional choices within a broader embeddedness of existing governance structures. So when we think about that and sort of the next iteration of this within the context of potential white papers and a broader audience of readers, given that we are in a neoliberal capitalist market economy, and so we situate ourselves within the social political thought that ensues from that, how significant is and again, what we're in these conferences to learn, because that's how we change minds and attitudes, but how significant is the role of consumer culture and the shifts in consumer culture in giving effect to the aspirations, and I guess the corollary of this is how limited is law and its capacity to do so before there is effectively what might be referenced as a market demand. So in terms of the metrics, and I'm reminded of 2 things from yesterday's conversations. One, I think it was Darcy Lindbergh, if I didn't if I heard him correctly, who referenced the language of the economics of life world, which has stuck with me. I'm hoping I heard that correctly, but it stuck with me and I've just been thinking about it. But also we heard, I forget who, and I apologize to the speaker, the reference to the historical meaning of economics itself and the idea of home accounts. So how can the change really start? Because we've had conversations of embeddedness from home accounts, from how we behave in the home and changes in consumer culture and cultural values. Thanks.
I just realized I should also have asked, would it make sense to take 1 or 2 questions and then ask the students to respond, or would you like to have the students just respond immediately to the first question?
Given our instructions, I only formulated the one question, but I'm happy to formulate others on the spot thereafter should time permit, but I'd be happy to hear from others.
Yeah, I actually meant whether we should ask the next judge and like take questions from a couple judges.
Well, I think why don't we just let them respond and then we can build from there. So if they've answered something that I was going to ask, then I'll switch my question a bit.
Sure thing. Okay, so why don't we just say, invite the students to respond to that question in the same order of the presentations, and then for the next one, we can sort of switch up the order.
I might pass on this one. I think my colleagues have more of the nub on this one.
I guess that's
I'd be happy to add, but I'd be happy to add if there's time.
So I think my paper doesn't really deal very much with what we can do in the home, but there's certainly some elements of, you know, capitalism and prioritization of market outcomes that certainly come into play. I spoke a little bit about how the difference between housing rights and food rights, like one of the key elements is the market, right? There's not really, and this is something that Nadia Lambic pointed out to me, so thank you so much. But there's not really like a market for housing that's restricted to specific provinces. So because certain provinces might have certain exports that are either going, you know, to different provinces or overseas, they might be a little bit reluctant to try to draw that back for the sake of fulfilling a right to food at home. Even if it is in the best interest of their communities. So the way that we prioritize, you know, market outcomes over feeding people at home is definitely a really big barrier in terms of actually, you know, getting the right to food and being able to make sure that everybody has access to food under that particular framework.
I appreciate this question actually, because I didn't have time to talk about it in the presentation, but there's a few ways that consumers can affect change in terms of voting with their dollar. And I want to like say that I'm going to have a caveat to that in a minute, but voting with your dollar can look like purchasing products that are third-party verified, such as fair trade. Fair trade has really high standards for labor, including the right to unionize, minimum wage standards, certain standards for health and safety. There are different kinds of fair trade. There's Fair Trade International, which actually has an even higher standard than Fair Trade USA. So as a consumer, if you're aware of these kinds of what these standards or labels mean, you can have an impact by choosing where to invest your money. The problem with that is it reduces people into consumers. It reduces them into economic beings where they're voting with money, which means that some people who don't have the money do not have that choice. And it's also a predicament in that, I mean, for example, the farm workers who are involved in this system would be excluded from making that kind of choice because they don't have the kind of money, because they didn't get a minimum wage, because they've been oppressed by this agribusiness system of farm labor. So I hesitate to say that is the solution. I think also because an economic solution is always entrenched in a capitalist system, which is, in my opinion, part of the problem in the first place. But there's so I don't know if the solution necessarily comes from home, but there are other ways to be an active participant in other than just an economic being. Like you can be in relation with other people and other organizations. There's programs called or known as worker-driven responsibility programs, and they're sort of like fair trade, but they're actually organized and facilitated by the workers themselves. So one example is the Coalition of Immokalee Workers, which is part of a tomato farm actually in Florida, where they've worked with Sodexo and Walmart to leverage slightly higher prices per pound for the tomatoes that they're harvesting. And also it's allowed them the ability to collectively bargain. So there's some like minimal human rights standards that they're getting access to there. But rather than a top-down enforcement like a third-party verified certification, it's coming from their own organization, and that can be really powerful. And I think rather than just seeing ourselves as economic consumers or participants, we can also see ourselves as working in solidarity with those kinds of projects, whether that means like reading about the kind of work they're doing, talking about it, or supporting those organizations through the work that we do in our everyday lives.
We'll need to speed up. We've got around 10 minutes left and 4 judges to ask questions.
I was going to say, I don't have too much more to add. So if we just want to move on to the next question, and that's okay with me, I can start the next one.
Thank you, Julia. Just in light of time, it really would be great if the remaining questions from the judges could be one question for one student, and that way we'll get to hear from everybody. Professor Farnese?
Sure. One question for one person. I guess I'll hear from Andrew. I'm most familiar with the topic, I suppose. Nobody gets into agriculture and food law because they have sort of a doctrinal issue and an interesting legal question. I think there's an undercurrent of advocacy that was in all of your papers. And we write these things because we want to promote, to change, to influence in some way. And so I would be curious, what would you like me, I guess, as a tribunal member, to take from your paper? What would you like me to, as I now have to interpret a new legislation, what do you want me to do with what you've identified as the trends are in our tribunal?
Good question. I think all I can ever hope for is for you to be forthright in your reasons. And the thing that I really appreciated about the tribunal was when the tribunal admitted that it was tough, admitted that it was kind of struggling with how to make a determination about something as nebulous as suffering. So I think I have less to ask of you and more to ask of the legislators, because I think they're giving you a very tough job. And I should have said, I said to you in chat that there were 2 tribunal decision makers. One of them was Don Buckingham and you were the other. So forgive me for not mentioning that at the outset. But I think that you've been handed an impossible job. So my main ask is for the legislative overlords, who I think maybe have given you better guidance as of 2020. So I think I admired the work that the tribunal was doing, and I appreciate it, and I would continue to ask that the tribunal be honest about within their reasons, and I would be more exacting of the legislators defining in the regulations what constitutes a violation.
Thank you. John Leckie, do you have a question?
Hi, I do. I just very briefly start by saying I'm delighted to be here in relation to an award named for our late colleague Joel, who was such a fun and charming colleague to have, in addition to being a leader in Canadian food law. So it's super nice to be involved in something that honors his memory. I just have a quick question for Tasha. I'm super interested in the politics. I don't know if it's an appropriate question, but I liked how your paper talked about practical strategies in terms of sort of how to address the reality of how to move the right to food forward. And you made some very interesting points about having the right players in the right place at the right time, and also about how Canadians working for the UN or UN agencies can sometimes play a critical role because of their insight into Canada. So I guess my question is, do I understand it correctly that for those of us who are interested in the recognition of the right to food, it's critically important to move this issue forward while we have a Liberal government that has made progress on the housing front, as I understand it, and paid lip service to the human right to food, and based on historical experience?
So I only really looked into the special rapporteur visits from 2007, and 2007 was the housing special rapporteur's visit, whose report was also ignored by the Conservative government at the time, and the 2012, which was also the Conservative government. I haven't been like politically conscious long enough. I'm still pretty young to be able to recognize patterns. But I would say that like we have a government, it doesn't necessarily have to be the Liberal government, but if we have a government that is committed, that has made commitments to forwarding our obligations under international human rights, because this is an ongoing problem, right? Like we've been signatories to these UN treaties for decades, and it's still not entrenched into our federal laws. And a lot of the reason that the Canadian government has been resistant to that has been issues of federalism. So I think that when we have governments who are and historically have been more willing to push change forward, we should take advantage of that. Because realistically, for example, I mean, I don't want to get too far into this, but under the current Conservative leadership, I do not see it happening at all. So yeah, I would say that, timing is everything. And I actually got the opportunity to speak directly to Leilani Farha, which was awesome. And she was very clear about the fact that like, it really was like, she knew the right people, she was in the right place at the right time, she had the right job at the right time. So I'm really interested actually in looking further into this, whether there is a correlation between UN Special Rapporteur or UN representative assignments or terms and the advancement of rights in their respective countries, because there are those connections, and there is that little bit of extra something of like, oh, I'm from the UN, like you have to do it. Also, I'm from Canada, like, so there seems to be some kind of correlation. I haven't really done enough research to see what it is exactly, but I would say that, yeah, better sooner than later. And we know that we have the right, maybe not the right government, we have a better government than we have in the past in terms of being able to push rights forward. So, yes, I would say the sooner the better for sure.
Awesome. Thank you.
Thank you both. Professor Shelley.
Thank you. What a delight to have been able to participate in this panel. So thank you very much to the organizers for asking me. And Tasha, I think we all think that we're young still and still learning. So my question was around framing. I really like to think about how we frame problems, and particularly in the context of food. And so something for all the panelists to think about, but I'm gonna pick on you a little bit, Julie, because you actually bring this up in your paper a little bit when you talk about the commodification of food versus it being a common good or recognizing the common good. But Celia, you kind of already kind of alluded to my question in talking about the ethos surrounding some of this area in the law. So what impact does the ethos around food have and how we regulate? And what is the right way to change that? This is an unfair question, Julie, but how do we change it? Do we first change the ethos of food and how we think about food, or do we use the law to change the ethos around food? It's kind of a chicken egg question to make it full circle with food.
Yeah, I'm not really sure. I think that previously I hadn't really, before law school, thought about how the law could even be involved in a change like that. And so I think that perhaps having using the law to set kind of a precedent and overall change of culture on how we view food could be beneficial, but it still may not be ideal. So I really do like the points that Celia, I think in the first question, was saying that a lot of the choices or things that are made still exist within a corporate system, and a lot of those principles will always be counter to kind of that goal. So I'm not sure if that answers the question. I'm not really sure, to be honest, which would be better, but or if either are possible.
To be fair, I don't think there is an answer. I think there's just argument. That's the best part. But in light of time, I'll leave it there for now. Thank you.
Legal and social theorists have struggled with that question for as long as they've been around. And Mark Uden.
Thank you, Stephen. And first off, like the other judges, I'd like to thank all the presenters, both for their well-prepared presentations and as well their thoughtful papers. The topics were all related, but also very different, which made for quite an interesting read. My question is for Andrew, and in particular, I guess, because I come from a litigation background, but I found it a very interesting topic because I don't know the CART. And so I was especially appreciative of how you highlighted the evolution of the Federal Court of Appeals commentary on the interpretation of the health of animals regulations over time. Specifically, did you or do you think it would be of benefit to consider analogous regimes as far as they exist to predict how the 2020 change to the health of animals regulations may be applied to CART? And sort of as a related question, are there any regimes or pieces of legislation that could assist the legislature in further reform, given the difficulty that you've identified for CART in its interpretations?
That's a great question, Mark. And I think it was easier to do that when you could compare undue suffering to unnecessary suffering, which was a phrase we saw in criminal law, and it's also out there in the laws of war. And I'm not sure if the word suffer, I haven't looked at where else that would appear, but one of the things that's interesting about the changes is that undue is gone, but also even suffering is much diminished. And so there's a lot more very clear definitions about what a fit or unfit animal is. So I think the regulations kind of retreat from the vagueness. So that's a good question, and I'm going to think about that. And I think the way it's worded now does not necessarily lend itself to an analogous regime that I can think of, but I'd like to think more. And thank you for that question.
Thank you.
And thank you, everybody. We are at time, and other than just once again thanking the panelists and the judges, I want to remind you, to tune in tomorrow at 1:15 p.m. Pacific time for the announcement of the winner of the Gowling WLG Joel Thaler Prize for Emerging Voice in Food Law. And secondly, to remind you that starting in 15 minutes, we have the screening of Alanis Obomsawin's film, Is the Crown at War with Us?, followed by an excellent discussion of the contemporary implications of that film for Mi'kmaq Indigenous fisheries today. So thank you, everybody, very much.